Hello to everyone joining us. We're just going to wait a minute or two whilst people join the webinar, and we'll get going in a couple of minutes. Okay, I think we will start. Good afternoon to everyone. A very warm welcome to this, the second webinar from the Doughty Street Inquest and Public Inquiries team. On reflection, I'm not quite sure why we've chosen to start with a picture of Doughty Street Chambers, the physical building. Perhaps it's a sort of, here's where you could have been, except of course we can't offer you wine, which is a shame. My name is Sam Jacobs. I'm the team leader at the Inquest and Public Inquiries team. For those of you who joined us for the last Inquests and Inquiries team webinar, you will recall that Jessie Nichols and Frederick Powell spoke to us about Article 2 and COVID-19 inquests, and in particular questions around the scope required of inquests in order to discharge the state's Article 2 investigative duty, and also some of the evidential issues around lack of or inadequacy of PPE and COVID deaths. Today we've got two topics for you. First of all, Turan Hursit is going to talk to you really about the sort of prior question of whether a COVID death or a possible COVID death needs to be referred at all to the coroner, and whether a coroner needs to open an inquest. It's really not a straightforward question, and given the horrible number of COVID-19 deaths, the answer to it has really quite significant implications for coroners' courts up and down the country. And anecdotally, at least, different approaches are being taken. So almost inevitably, we as lawyers who often represent bereaved families are going to find ourselves making representations to coroners on the issue. And it wouldn't be at all surprising if there's the odd judicial review as well. So that's going to be our first and slightly longer topic. The second topic is virtual hearings, and Chris Johnson is going to talk to us about that. Whether we like it or not, the reality is that virtual hearings are probably going to be here to stay for a while at least. And bereaved families are finding themselves, in my view, in quite an invidious position of having to choose between a virtual hearing, which perhaps justifiably they may feel is a lesser form of inquiry, but on the other hand, fighting for an in-person hearing, which may not happen for months, if not years, and having to wait that long for inquiry into their loved one's death and obtaining a sort of closure. So Chris is going to talk to us about some of the relevant provisions, but also share some reflections from us as advocates as to how effective we feel virtual hearings can be. We think will be about 45 minutes with presentations, and then at the end of that there's going to be opportunity for questions and answers. And can I ask you, if you have a question, to use the Q&A function. So you'll probably see both a Q&A button and a chat button, but please use the Q&A button and we'll address your questions as best we can at the end of the webinar. For those of you who have attended, at some point after the webinar, we're going to send out to you both a recording and a copy of the slides so that you have that. And also, if you weren't able to join us for the first webinar but would like access to it, then please feel free to contact the clerking team at Doughty Street, and we will happily give you access. With that, I'm going to turn you over to the very skillful hands of Turan Hursit. Thank you.
Thanks very much, Sam, and thank you everybody for joining us this afternoon. I'm going to kick off today's webinar by attempting to answer 4 questions that might be in your minds following the various guidance documents that have been issued by the Chief Coroner. Sam, if I could have the, yes, that slide, please. Here you'll see the first 4 questions that I'll be addressing. First, the circumstances in which there is an obligation to report a COVID death to a coroner. Second, the circumstances in which a coroner should request a post-mortem. Third, when a COVID-related inquest should be held, probably the most important question that we'll ask today. And finally, the way in which COVID-19 inquests may be conducted. And then I'll pass over to Chris, who'll deal with virtual hearings. Now, I've started off by listing some of the guidance documents that have been issued by the Chief Coroner since the beginning of COVID. In summary, there have been 5 guidance documents and also, of course, a few select provisions within the Coronavirus Act 2020, which I'll also address today. And I've listed also various other pieces of legislation that will come into play when interpreting these pieces of guidance. So let's start with the circumstances in which there's an obligation to report a COVID-19 death. Well, the first thing to note here is that COVID-19 has been listed as a notifiable disease under the Health Protection Notification Regulation 2020, which means that it must be notified to Public Health England. I assume that the primary reason for that is simply to facilitate tracking of the number of deaths in the pandemic and also the efficacy or otherwise of the measures that the government is currently putting in place to deal with it. Of course, just because a death is notifiable to a public body doesn't necessarily mean that a coroner will need to become involved. And that is made clear in paragraph 19 of guidance, paragraph 18 of guidance number 34, and again on page 3 of the subsequent guidance number 36. I've summarised on the next slide the most important part from guidance number 36, which essentially says that there will often be no reason for deaths caused by this disease to be referred to a coroner. Now, really, if you've read the guidance, you'll see that it chimes with the message that is sent in the guidance, which is that because of practical delays in hearings as a result of COVID and essentially the likely backlog that we're going to be facing when the courts do start up again, it's only really in unusual cases where there is reason to suspect that there might have been some form of state involvement or an unnatural cause of death that a coroner will need to become involved. In other cases, the procedure that has been prescribed is for the medical practitioner in question to complete a medical certificate cause of death, MCCD, which is specified in paragraph 20 of guidance number 34. And that is something that doesn't require input from a coroner. We see, though, that guidance number 34 does outline 2 scenarios where it might be appropriate to report a COVID-19 death to a coroner. The first of those is where a doctor is unable to sign an MCCD, and that's specified at paragraph 22 of guidance number 34. And that does include situations of suspected rather than confirmed COVID-19. That may well be, practically speaking, it might be in scenarios where, for example, there hasn't been final examination of the body for various public health reasons, where it has been unable to perform a post-mortem, and where the medical practitioner in question feels that they're unable to reach a conclusion on the balance of probabilities. In those kinds of scenarios, they might say, actually, I'm not in a position to sign the MCCD, it therefore must be referred to the coroner. So that's the first scenario. The second is where there are additional factors requiring reporting, and the wording of additional factors is drawn from paragraph 19 of guidance number 34. Now, those factors are undefined in the guidance itself, so I took the liberty of looking at a few NHS guidance documents for doctors about the MCCD procedure in usual times. And these make clear that the relevant factors that are likely to arise here are where, for example, there's a death in state custody, where there's been an unnatural event, process or intervention which might have contributed to the death in more than a negligible way, or in a hospital context where there has been a loss of opportunity to give timely treatment to somebody such that, again, there might have been a potential contribution. So really it's just the standard scenario in which an inquest would usually be heard in normal times. The guidance does make clear that coroners are not the only bodies who might be involved. First of all, we've of course got Public Health England, who will always be notified when there is a death, and that is made clear in paragraph 5 of guidance number 37. The second is, I suppose, a less obvious body, and it's the Health and Safety Executive, HSE. Now, guidance number 37 was issued specifically to deal with the question of deaths in the workplace or deaths resulting from contraction of disease in the workplace. And paragraph 5 of that guidance is relevant in this context. So you'll see on the slide that paragraph 5 says that deaths may also sometimes be notifiable to the HSE under the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations 2013. Regulation 6.2 of RIDDOR requires a report to be made where any person dies as a result of occupational exposure to a biological agent. The expression biological agent includes the virus which causes the COVID-19 disease. Consistent with the requirements of RIDDOR, the HSE has published guidance that death as a result of work-related exposure to the virus must be subject to the reporting procedure. So what we see is, because of the way the regulations are set up, it doesn't automatically mean that death must be reported to the coroner. The relevant regulation here is regulation 3.1a, which I've put in full on the next slide. And regulation 3.1a says that essentially there must be a report to the coroner if the medical practitioner suspects that the person's death was due to an injury or disease attributable to any employment held during the person's lifetime. Now, the regulations themselves don't define the words attributable to, nor do we see any definition of those words in the guidance. So there is no clear vision here of what that causative relationship must look like for a referral to be necessary. And the paragraph 7 of guidance number 37 appears to suggest that it's a broad definition that's appropriate. So essentially it says, there are therefore some instances in which a COVID-19 death may be reported to the coroner, such as where the virus may have been contracted in the workplace setting. So may have, of course, being quite vague wording there. And the guidance then gives examples of professions such as those held by frontline NHS staff, public transport employees, care home workers, and emergency services personnel. So we see here that we've got a fairly low threshold being imposed by the original words of may have been contracted in the workplace setting. We've also got the words attributable to coming up in regulation 3, which are undefined. And overall, it seems to say that there's going to be quite a low threshold coming into play when deciding when it is that the HSE needs to become involved and subsequently a coroner. Ultimately, I think it's going to be quite difficult to say where the virus might have been contracted, because we're still behind on scientific research of the virus, and there's only really at this stage a very broad understanding of how it can be transmitted. So I think the reality is that there is likely to be a notification requirement in most of those cases where there is somebody who's a frontline member of NHS staff or somebody in a high risk profession who's contracted the virus, because the implication is that they're far more likely to have contracted that virus in the workplace than they would be if they were at home or doing something else. Let's move now to our second topic, so the circumstances in which a coroner should conduct a post-mortem. First of all, I should start by saying that the guidance makes clear that if there is an unsigned MCCD, and if the coroner is not sure that the duty to investigate under section 1 of the CJA is engaged, normally they can request a post-mortem examination. So it's no obligation, but the option is there for coroners. And then if there isn't a natural cause that is subsequently identified, then there can be registration and that's made clear in paragraph 23.4 of guidance number 34. So if on the evidence the coroner has before him or her there's uncertainty about whether the death was unnatural, or if the cause of death can't be given on a balance of probability standard, then we've got this option that comes into play. There is, however, then some ambiguity in the remainder of the guidance on precisely when an inquest should occur once a post-mortem has been requested but can't be carried out. So we've got two slightly contradictory provisions here. The first is paragraph 23, subsection 6 of guidance number 34. And that starts off by telling us that if the coroner considers that an investigation may be necessary, but that a post-mortem examination is not practicable within a reasonable time, the chief coroner's view is that coroners should open an investigation into a death if at all possible and proceed to inquest. Coroners are reminded that they cannot discontinue an investigation where there has been no section 14 post-mortem examination. So the message there is essentially once you initiate this investigation process, you have to carry it through until the end, regardless of whether or not the post-mortem is carried out. And that essentially means proceeding with an inquest. In the next paragraph, though, the guidance then states at paragraph 34.6 that coroners are further reminded that the reason to suspect test in section 1 is a low threshold, and that although the death may be suspected COVID-19, there are likely to be enough grounds in law to consider the cause of death unknown at this stage. Accordingly, a coroner who's notified of a death but cannot establish the position satisfactorily and or cannot arrange a post-mortem examination in a reasonable time may need to proceed to inquest. So now we've got the wording of may rather than must, whereas previously the wording was the wording of should, so mandatory. I mean, if we read the provisions in the context of the guidance as a whole, I think it's actually a question of semantics. And given the low emphasis, the emphasis on the low threshold in the guidance, I think it's the former view that should prevail, that actually an inquest should be proceeded with if a post-mortem is not possible. What about then when post-mortems are not an issue? When should an inquest be held in those circumstances? Well, I think it's probably easiest here to start with the pre-COVID provisions and legal definitions, because we'll see throughout the webinar that actually it is the status quo in the existing legal position that continues to prevail in the post-COVID era. So we start with section 1.1 of the Coroners and Justice Act, with which many of you will already be familiar. And that says that essentially there must be an investigation into a person's death if subsection 2 applies. Subsection 2 in turn says that it applies if the coroner has reason to suspect that the deceased died a violent or unnatural death, the cause of death is unknown, or the deceased died while in custody or otherwise in state detention. There's no controversy around the fact that reason to suspect is a fairly low threshold. That's been made quite clear in the case law applying to these provisions. But the definition of unnatural death has been slightly more controversial as it has progressed. So far in the case law, it's been defined in two ways. So first of all, we see that it applies to situations where the death has been contributed to by neglect. So this is your standard situation of state conduct bringing about or contributing to death in some way, given that death doesn't have to be established on a but-for basis. For example, if there has been delayed or misdiagnosis of cancer in a prison context, or if there has been insufficient mental health input provided to an inpatient in a psychiatric ward. So that's your first scenario. It's a fairly uncontroversial one. The second, slightly more controversial scenario is where there is an unexpected death resulting from natural causes, but it results from human failure. So we've got a natural process, a natural medical process, but the cause of that process may not be natural because it might have been brought about by human conduct. Now, the leading case on this is the case of Touche and HMC Inner London North, a 2001 case where unnatural was defined as abnormal and unexpected. And it was held there that culpable human failure could render a natural death unnatural for the purposes of Section 81A of the Coroners Act 1988, which preceded the current Act. The most relevant paragraph is on our next slide. And it says there that essentially there will be cases which fall outside of the category of neglect and yet appear to call for an inquest on the basis already indicated, namely involving a wholly unexpected death from natural causes, which would not have occurred but for some culpable human failure. It is the combination of their unexpectedness and the culpable human failing that allowed them to happen, which to my mind makes such deaths unnatural. And I flag this really because despite the fact that the position seems to be quite settled in that case, and subsequently it is something that still comes up. I've certainly had it come up in inquests where I've had a pre-inquest review hearing, and it's been a coroner's kind of queried this unnatural-natural division, and a state body has attempted to argue that it doesn't apply. So it's certainly still relevant. So that's the primary case you should cite for that too. There's another case called Bicknell and HMC Birmingham, which I won't go through. I've put the facts and the relevant points on the slide there for you to read afterwards. Suffice to say that it essentially reinforces what was already said in Touche. Now, how does this apply to the COVID provisions and definitions that we've seen since the beginning of the pandemic? Well, the issue of when to hold a COVID-related inquest outside a post-mortem scenario was first addressed in paragraph 17 to 19 of the Chief Coroner's Guidance number 34, which was the first note that was issued. The guidance there starts by reminding coroners of the notification of death regulations, which provides in section 24 that a death is typically considered to be unnatural if it has not resulted entirely from a naturally occurring disease process running its natural course when nothing else is implicated. And the guidance then goes on to say at paragraphs 18 and 19, previous slide please, COVID-19 as a cause of death is not a reason on its own to refer a death to a coroner under the CJA, and that COVID-19 is now a notifiable disease under the health protection regulations does not mean referral to a coroner is required by virtue of its notifiable status. So those are the first two paragraphs. On our next slide, we then see a provision within paragraph 19, which summarises the position. And it says there that COVID is a naturally occurring disease. There may be additional factors around the death which mean a report is necessary. And there may also be cases where an otherwise natural causes death could be considered unnatural. So we see here the wording of those provisions essentially makes clear that we've got the existing legal position that is going to prevail in these cases, and that if there is some kind of more than minimal contribution by a non-natural cause, then there will need to be referral to a coroner. So no change in the position so far. What about institutional settings? I'll discuss with you two practical scenarios where we might see these provisions apply: institutional settings and the workplace as well, because those are the ones that I expect will probably come up a lot in cases. Institutional settings first. Next slide, please. So in section 1 of the Coroners and Justice Act, we see that an inquest is a mandatory requirement where the deceased died whilst in custody or state detention. So we see immediately it will cover situations where we've got prisoner deaths or deaths of those in state custody. The question, of course, is whether state detention can apply in other contexts, like in care homes and hospital admissions, if individuals are deprived of their liberty and not free to leave in those settings. Now, I suspect this is going to be really important for us to consider, because the Office for National Statistics published its latest statistics for the week ending 12th of June 2020, just a few days ago. And the very tragic news was that we'd already had 11,880 care home deaths notified to the CQC. So that obviously doesn't include any unregistered deaths that we don't know about. So it is likely to come up a lot in an inquest process, in an inquest context, I think. So we need to be prepared as practitioners to deal with the possibility of care home deaths. Well, what is the legal position? Historically, it was quite unclear. So we had initially Chief Coroner's Guidance number 16, which expressed the view that any person subject to an authorised deprivation of liberty, which for those of you who don't practice in the Court of Protection, which I do, so I'm sorry if I've assumed knowledge, but that a deprivation of liberty safeguard is essentially what's put into place to legally authorise detaining somebody against their will, if it's considered to be in that individual's best interests. And it's the Dole's regime came in to provide legal authority for those deprivations of liberty. So the Chief Coroner's Guidance number 16 addressed the issue first. It essentially said anyone subject to an authorised deprivation of liberty under the Dole scheme does come within the CJA's definition of state detention. We then had the case of LF, which you'll see on the slide there, where the contrary was held, and it was said that not all patients deprived of their liberty in a hospital setting and care home setting should be treated as being in state detention for the purposes of inquest provisions. It was finally clarified with the addition of section 48 subsection 2A to the Coroners and Justice Act that a person is not in state detention at any time when he or she is deprived of their liberty under section 4A3 or 5 or 4B of the Mental Capacity Act, which are the provisions relating to the Doles regime. And we then had a fairly lengthy guidance document, the guidance number 16A, that was published by the judiciary to supplement that. And there the position was clarified. It was said there that for deaths to which section 48(2)A applies, there is no mandatory and automatic requirement for a coroner's investigation on state detention grounds if the person was subject to a deprivation of liberty authorised under the MCA. Of course, there may be a requirement for an investigation on other grounds, for example, if there was an unnatural death or police custody. Furthermore, a person who dies while subject to restrictions amounting to state detention without an authorised deprivation of liberty will still have to be the subject of an investigation in an inquest. So the answer seems to be that where there is a legal authorisation of a deprivation of liberty, then there's no automatic requirement for an inquest if that person has died in a care home or if they've died whilst being deprived of their liberty in another context. But if there was no legal authorisation in place by a local authority or other supervisory body, we then have a situation where an inquest is required. And of course, there is also the point that other provisions, unnatural death, for example, or other unclear causes of death may still require an inquest to be held. What might this look like in practice? Well, I thought it might help to cover a few situations where there might be an inquest and where there might not be an inquest. In my view, and this is just my view, that there might not be an inquest, on our next slide we see, in situations where a sufferer of dementia in a care home has constantly objected to a placement, but the local authority has put into place a standard authorisation to legally deprive him or her of his liberty. There is then a COVID outbreak in the care home, that person dies, and the care home is able to show that there were very sensible measures in place in order to prevent a spread of COVID in the care home. So proper social distancing, PPE equipment that's properly provided and abided by. That's the kind of scenario where I don't think an inquest will be held. By contrast, we have two situations where an inquest might be held in a care home context. First, there's an automatic requirement where there's a sufferer of something like dementia, and I just give that as an example of a disease that usually ends up with people ending up in these care homes. Someone who's constantly objecting to their placement, but there's no standard authorisation in place, then there's an automatic requirement for an inquest. Second, there are discretionary scenarios where it might come up. For example, where you've got a care home where the legal safeguards have been followed, but where there might be potential deficiencies in the care or in the way in which COVID has been dealt with in that particular care home. So, for example, if you've had a care home where there's been no proper social distancing, or at least where it hasn't been enforced, where there's no PPE, although note that there's been a lot of guidance on this and it's been completely inconsistent and changed throughout the pandemic, so you'll need to find whichever guidance applied at the time. Another scenario could be where there's PPE worn, but for example, where it hasn't been changed between residents and it might have led to an outbreak in the care home. So those are scenarios where there are red flag signs, which to me would suggest it might be an inquest scenario. I've written on this slide a few pointers for your evidence gathering in these cases, the kinds of documents that you may wish to ask for when investigating these, any deaths that you might meet in care homes. I think the most obvious is to ask how many deaths there have been in the care home, just to see if it's a systemic issue and whether it's something that's likely to have been contracted in that placement. Other things you might want to ask for are COVID policy documents, records of any COVID testing within the care home, and records of enforcement of COVID measures. And finally, statements from carers who might have had physical contact with the deceased to see at which point it might have been transmitted. So that's your care home scenario. Let's move quickly on to our second scenario, deaths that might have taken place as a result of working in a particular environment. Well, the same rules to those I've already elaborated here apply here. We've got the natural and unnatural causes distinction, which was really set out at paragraph 9 of guidance number 37, which says that there's no, if the medical cause of death is COVID-19 and there's no culpable human failure, then there will usually be no requirement for an investigation to be opened. So we have the standard situation that applies there. What might this look like in practice in a workplace context? Well, I'd say that there's probably unlikely to be an inquest where you've got a natural death from COVID caught in the workplace despite all government guidance having been followed and properly implemented. By contrast, you might have an inquest where there's been flagrant disregard by an employer of government guidance, where it's only been partially implemented. And finally, I flag the point of whether it might be possible to consider the effectiveness of guidance, of the government guidance that was in place. Now, I'll get to this in a moment when I discuss scope, and it has been addressed by my colleagues Freddie and Jessie in the last webinar. But there is still some leeway to explore these issues on a local level, at least in the course of inquests. And again, I've listed there some evidence gathering points that you might wish to consider when investigating these kinds of cases, things like policies in the workplace, details of PPE in the workplace, registers of whether that PPE was worn, and medical records, of course, as well, relating to the employee. I'll move now on to consider some practical considerations that might apply to whether or not an inquest is held. Now, we see that the first guidance note that was published, so guidance number 34, was riddled with concerns about how the system would cope with investigating a potentially high number of deaths. And actually, we see in the guidance that even in the event that an inquest is appropriate for legal reasons, there is significant discretion left to the individual coroner to decide whether it should go ahead. And there are two very important paragraphs in guidance number 34 in this respect. The first is paragraph 23, subsection 8, which says that if it is possible to hold a short inquest soon after the report of death, then a coroner should do so. More importantly, paragraph 23.9 and 23.10 says the following. It says, circumstances on the ground, such as the closure of public buildings or other factors such as staff absence, may make it impossible to hold an inquest. Coroners will only be able to work with the medical and other evidence available to them. We may all have to accept that the unprecedented situation we are in may mean it may not be possible to perform the sort of detailed death investigation process we are used to. For example, it may not be feasible to order a post-mortem examination on many of the deaths where COVID is suspected, where it's present, or indeed where it can't be ruled out. Coroners remain under their usual statutory duties and must conduct proper investigations, but they are advised to exercise judgment. My reading of that paragraph is that the chief coroner is saying that coroners' statutory duties have not been relaxed as a result of high potential demand on the need for an inquest, but that inquests themselves may need to be run on imperfect evidence, and that coroners have significant discretion in deciding how to run them. One would expect that we may well have a scenario where we have an increased number of open conclusions. And I do query how this sits with the existing guidance that we have, which essentially says that open conclusions are to be a measure of last resort only. So we can remind ourselves here of paragraph 68 of guidance 17 on the slide in front of you at the moment, which says open conclusions are to be discouraged, save where strictly necessary. An open conclusion should be used only as a last resort, notably when the coroner is unable to reach any conclusions on the balance of probabilities. I think inevitably we are likely to see an increase of those kinds of conclusions post-COVID. Moving now on to my final question of how inquests will be conducted. And I'll talk about two things here. The first of those is juries and the second is scope. Now, the question of juries was the only thing that was addressed in the Coronavirus Act in relation to inquests, and it was addressed at section 30 of that Act. Section 30, in that's where usually we have this requirement for an inquest to be held if with a jury, if the senior coroner has reason to suspect death was caused by a notifiable disease, then that requirement doesn't apply in a COVID context. We've then got the explanatory notes on our next slide, which elaborate on this. And those notes make very clear that there are resource queries that are in the minds of those who wrote this legislation, that they have queried the possibility of 25,000 additional jury inquests at the time. Of course, now we've surpassed 40,000, so the resource issues are even more pertinent. And they then say that essentially to simply adjourn matters would delay resource pressure for the future. So there were clearly resource issues at the forefront of the legislators' minds when those provisions were drafted. Of course, it doesn't change the fact that if there are other mandatory provisions within Section 7 which apply, then a jury will still be required. So if there is a death that was in state custody, and if the death was a violent or unnatural one, or the cause of death is unknown, or if the cause of death, or if the death resulted from an act or omission of a police officer or member of the service police force. And of course, we also have the discretionary provisions in Section 7.3, which continue to apply. So where the coroner thinks there is sufficient reason for holding an inquest with a jury. So that's the jury issue dealt with. I'll move now on to my final topic, that of scope. Now, I don't propose to address this in any great detail because it has already been addressed by my colleagues Jessie Nichols and Frederick Powell in our last webinar. And as Sam has highlighted, you can contact our clerks for that. But there is an inevitable degree of overlap between the topics because I think there will be all sorts of issues that arise about whether an inquest can take place in the event that there has been a death which may have been more than trivially contributed to by a state body in some way, but whether act or omission is part of a wider, more systemic problem concerning how the COVID crisis has been dealt with. I'd just briefly like to remind you of the very controversial provisions that came out in guidance number 37 at paragraphs 13 to 14, where it was said that an inquest is not the right forum for addressing concerns about high-level government or public policy. Now, as I said, my colleagues have already outlined why that was problematic. To remind you, one of my concerns was that it could be a potential breach of the Article 2 duty to investigate. It was also problematic because the cases that were cited, the cases of Scholes and SSD and Smith and Oxfordshire, were cases in which the comments made were only obiter. And actually, the guidance itself didn't seem to take account of a whole swathe of policy-related case law that has followed. In brief, sorry, Sam, next slide, thank you. We had situations where, for example, absences of policy can breach Article 2, where the policy framework itself can be assessed for its compliance with Article 2, and where there are repeated operational errors which may well amount to a systemic fault. So we see there that there are problems with the guidance so far. I've queried there whether we can still have exploration of those issues via local policy issues, which the guidance makes very clear can still happen. And of course, we also have the existing preventing future deaths duties of coroners existing under Schedule 5, paragraph 7, which continue to apply. The second query I make is whether we'll have a public inquiry. Well, since the last webinar we hosted, we've been following it closely, but unfortunately nothing has been forthcoming on the point yet. There have been a number of petitions that have been signed, some by some of you who might have joined us today, because I know that there was one by lawyers representing bereaved families calling for a public inquiry, for example, but we don't know where the government will take that. I can't say very much on it other than watch this space. We'll let you know if there is any further progress on it, and we'll probably do another webinar on it at that stage. That's all from my section. I've run over slightly, sorry Chris, but I'll hand over to Chris now to discuss the issue of virtual hearings.
Over the past weeks, the restrictions imposed to prevent the spread of COVID-19 have been gradually reduced. We're now able to meet outdoors with up to 6 people. Schools have been reopened for children in reception year 1 and year 6. Non-essential shops have been allowed to reopen, and most importantly of all, on Friday we'll be able to watch Manchester United for the first time since March. Despite the general easing of restrictions, the guidance on hearings in the Coroner's Court remains as it was when lockdown began. The only hearings that should be going ahead are those which are urgent and essential. The reason for this is perhaps that awful phrase, social distancing. The government's guidance continues to be that people must keep 2 metres away from one another. The practical effect of this is that many in-person hearings in the Coroner's Court will be unable to proceed. The last inquest in which I acted in person is illustrative. I represented the family of a man, Mark, who took his own life whilst evading police. There were questions about the conduct of the police manhunt. The hearing was attended by 10 members of Mark's family, by Mark's ex-wife and her mother, by 4 police witnesses, 2 further representatives of the police, by the police solicitor, my instructing solicitor, and by myself. Now that's 21 people, not including the court staff or the coroner himself. And this is not uncommon. For instance, the last medical inquest in which I acted was attended every day by 13 witnesses on behalf of the trust and by 6 members of the deceased's family. Unless there's a radical change in the government's approach to this pandemic, this type of in-person hearing in the Coroner's Court is going to be impossible for the foreseeable future. This issue is not an issue which is just going to go away. One solution to the social distancing problem is virtual or remote hearings. And last Thursday, the Chief Coroner issued guidance number 38, which is entitled Remote Participation in Coronial Proceedings via Video and Audio Broadcast. This document encourages coroners to make use of what are termed partially remote hearings, i.e. hearings where the coroner is present in the court but the other participants join remotely. Paragraph 8 of the guidance is on the screen in front of you. It states, the current pandemic has increased the need to use technology to facilitate remote participation in hearings. It is the Chief Coroner's view that partially remote hearings should take place wherever possible, if the technology allows. It is in the interest of justice and its use is consistent with the administration of justice. Inquiries are perhaps slightly ahead of inquests when it comes to virtual hearings. For instance, the Independent Inquiry into Child Sexual Abuse has held virtual hearings in the Child Protection and Religion and Organised Settings strand, and is set to hold virtual hearings in its Lambeth Council strand beginning on the 29th of June. The Undercover Policing Inquiry too is set to hold virtual hearings, and that'll begin in November. We anticipate that there will be an increasing number of virtual hearings in the coming months. And therefore, my part of the webinar is on virtual hearings, and it's in 2 parts. First, the rules regarding virtual hearings, and second, ensuring virtual hearings are effective for the family. Turning to the first of those topics, the rules regarding virtual hearings. When I was writing this presentation last week, my notes on this topic traversed multiple sources, including the Coroner's Inquest Rules 2013 and the Chief Coroner's Guidance numbers 34 and 35, which were issued at the end of March. Then, as I said, last Thursday, the Chief Coroner's Guidance number 38 was released, and so I tore up my notes and started again. That document is now the most comprehensive source for the rules on virtual hearings, and I'll summarise the most important points. First is that partially remote hearings, or hearings where the coroner is in the court and the other parties join remotely, are permissible. But the decision to proceed remotely is governed by the coroner's inherent common law jurisdiction to manage their own proceedings. If a coroner is considering proceeding remotely, they will need to take account of the views of the parties. Paragraph 23 of Chief Coroner's Guidance number 38 is on the slide now. It says, coroners can order a partially remote hearing. If they are to do so, they need to give those affected an opportunity to make representations and will need to consider those alongside an interest of justice test. If making such a ruling, the coroner should set out their reasons to interested parties at the conclusion of any pre-inquest review or in writing by letter or email. Except in the most exceptional and limited circumstances, remote hearings are not suitable for jury inquests. There's also provision in Chief Coroner's Guidance number 38 for the attendance of members of the press and the public. I won't go too far into this. It's a topic in and of itself and not one on which I can profess any real expertise, but in brief, it may be possible for members of the press or public to attend a partially remote hearing by being physically present in the courtroom. But if that's not possible, then there are other options. The first is that it's permissible to relay a live feed of the courtroom to an adjacent room, which is then regarded as an extension of the courtroom itself. Otherwise, it's permissible for members of the press or public to listen to proceedings live via an audio-only line, but it's not permissible for them to watch the proceedings via a live stream. For anyone wishing to know more about open justice issues and virtual hearings, then 2 articles on the Doughty Street Insight page are recommended. The first is Resumption of Jury Trials, an Open Justice Toolkit by Claire Duffy, and the second is Open Justice During Lockdown by Keelan Gallagher QC. I've linked to both of those on the PowerPoint, which will be sent out. My own view, for what it's worth, is that there should be a change to legislation to allow virtual inquests to be live streamed, and that will allow much more meaningful participation by the public and the press. Turning now to my second topic, which is ensuring that virtual hearings are effective for the family. I'm going to address 2 issues. The first is the decision to proceed virtually or not, and the second is how to have an effective virtual hearing. Starting with the decision to proceed virtually or not. As I set out previously, the decision to proceed remotely or not is governed by the coroner's discretion. But if the coroner is considering proceeding remotely, they must invite and consider representations from the parties. If you're involved in a case where the coroner has indicated that they are considering proceeding remotely, then you'll need to take instructions from your client. You'll need to talk your client through the advantages and disadvantages of proceeding remotely. The principal advantage is expedience. In the situation we are in, the reality is that the choice in most cases will be between proceeding remotely or an indefinite stay. On the other hand, there are many potential disadvantages of proceeding remotely, and they're on the slide now. They include length. The hearing itself will take longer, and perhaps much longer, if it proceeds virtually than if it would proceed in person. Second, that there's no opportunity for informal discussion between legal representatives before and after the hearing. Third, that remote hearings lack the formality of in-person hearings, so they may be perceived by the family to be less just. Fourth, the evidence that is adduced may differ, and the coroner's perception of that evidence may differ, so the remote hearings may be less thorough or may be perceived to be less thorough. My own view is that this is particularly important in hearings where there are witnesses whose evidence needs to be vigorously challenged. My view is that this will be more difficult and less effective in a virtual hearing. The fifth disadvantage of virtual hearings is that remote hearings have potential technical and practical difficulties, and I'll come back to this in a moment. Sixth is that press access to remote hearings is reduced, and we touched on that a moment ago. This will be particularly important if public exposure is important to your client. Seventh is that effective participation of the family may be more difficult in virtual hearings, as to which see the responses to the Nuffield Family Justice Observatory Rapid Consultation on Remote Hearings, which I've linked on the PowerPoint. The eighth and final issue is that remote hearings pose difficulties in sensitive cases. And again, this is detailed in the Nuffield Family Justice Observatory consultation, which I've linked to. Once you have taken instructions from your client, you'll need to make submissions on why it is or isn't appropriate to proceed remotely. And these will need to identify all of the relevant factors on which you are relying. Allow me now a brief detour. There have been a number of cases in the civil courts in which the courts had to consider whether or not a hearing should go ahead remotely. And it's worth being aware of those cases in the inquest context, because many of the arguments are equally applicable. I'll touch on 2 cases. The first is Re-P, a child remote hearing. And in that case, Sir Andrew McFarlane, president of the Family Division, was asked to consider whether a 15-day final hearing in care proceedings should go ahead remotely. The issue to be considered at the final hearing was whether the child had been harmed through fabricated or induced illness. And Sir Andrew McFarlane held that the hearing could not go ahead remotely. He explained at paragraph 26 his reasons. and that's a long passage of text, which you'll forgive me for reading. He said, the reason for having the very clear view that I have is that it simply seems to me impossible to contemplate a final hearing of this nature, where at issue are a whole series of allegations of factitious illness being conducted remotely. The judge who undertakes such a hearing may well be able to cope with the cross-examination and the assimilation of the detailed evidence from the e-bundle, and for the process of witness examination, for the process of witness appearing over Skype. But that is only part of the judicial function. The more important part, as I've indicated, is for the judge to see all the parties in the case when they're in the courtroom, in particular the mother. And although it's possible over Skype to keep the postage stamp image of any particular attendee at the hearing up to 5 in all live on the judge's screen at any one time, it's a very poor substitute to seeing that person fully present in the court. It also assumes that the person's link with the court hearing is maintained at all times and that they choose to have their video camera on. It seems to me that to contemplate a remote hearing of issues such as this is wholly out with any process which gives the judge a proper basis upon which to make a full judgment. I do not consider that a remote hearing for a final hearing of this sort would allow effective participation for the parent and effective engagement either by the parent with the court or, as I've indicated, the court with the parent. I also consider that there's a significant risk that the process as a whole would not be fair. The second case, which I'll turn to, is SC and the University Hospital Southampton NHS Foundation Trust. This was a clinical negligence claim, and the defendant sought to argue that the trial should not go ahead remotely and relied on the decision of Sir Andrew McFarlane in Re P. However, Mr. Justice Johnson distinguished Re P and held that the trial could proceed remotely, although only if an in-person hearing became impossible. Paragraphs 17 to 23 of the judgment consider whether a remote hearing would be fair and are worth considering in full. Paragraph 23 is the conclusion and reads as follows. The nature of a private law civil action in clinical damages, in clinical negligence for damages is very different from a public law family case involving allegations of fabricated or induced illness. To the extent that the observations of the President read across to this different context, I consider that the risk of unfairness can, if necessary, be sufficiently addressed and managed by the trial judge. The clinicians are experienced professionals who are well used to communicating in difficult and stressful conditions, if not by video conference in a court hearing. Case management directions informed by the valuable work of the Nuffield Family Justice Observatory, see paragraph 28 below, can be imposed which ensure that the disadvantages of a remote hearing in this case are reduced as far as possible, and to a much greater extent than would have been possible in a very different context of 3P. So these cases show that whether or not a remote hearing is fair is very much fact sensitive. And in my view, that clearly transfers over to the context of inquests. Turning now to my next point, if a hearing is to proceed virtually, how can we ensure that the virtual hearing is effective for the family? Putting aside advocacy-related challenges, which are for us as counsel to deal with, in my view, the challenges posed by virtual hearings fall under 3 headings. The first is technical difficulties. Access to technology and technical literacy cannot be presumed. One of the things that's most astonished me over the past few months is how many parents and grandparents are able to log on to the Zoom call, but are then unable to unmute their microphones. On a serious note though, access to technology and technical illiteracy are problems that disproportionately affect the poorest people in our society. According to 2016 research by the Back Commission, only 50% of people who would have been entitled to civil legal aid pre-2013 would be willing and able to participate in court proceedings online. The second challenge of remote hearings is ensuring lay client understanding. If the lay client is not in the courtroom or with their legal team, then it becomes difficult to ensure that they're understanding what's going on. The third challenge is taking instructions. And again, this is difficult if the lay client's not in the room with the legal team. Having identified these 3 challenges, let me now suggest some solutions. The first solution is that when there's going to be a virtual hearing, we should be asking for the directions to include the following. And an overview of this is on the slide in front of you. Firstly, a provision for a test run. So the day before the virtual hearing, a time should be allotted for a test run so that the parties can ensure that all participants can connect to the call. Where possible, a technician or member of court staff with requisite knowledge should be available to deal with any difficulties that arise. I have a friend who's in the Court of Appeal next week, and I know that this is what has been arranged for his hearing in the Court of Appeal. The day before the hearing, the parties will all get onto the line to check that they can do so. Secondly, the directions should include provision for people to join the meeting prior to the start of the hearing. This just gives time to address any unexpected or last-minute technical difficulties. Third, the directions should include detailed instructions on joining the hearing, and this should include the platform that will be used, who is to be responsible for arranging the hearing, and step-by-step instructions on joining the meeting. Fourth, there should be directions on what will happen during the hearing, including, for instance, the topics to be addressed in submissions, the order for submissions, the order of witnesses, the order of questioning. And there should also be directions on how to take instructions should the need arise, ideally through a breakout facility in the conferencing platform, but otherwise by muting the conference and communicating via another means. Fifth, there should be directions on how to effectively raise technical problems, for example, by using the chat function in the conferencing software or through a WhatsApp message between solicitors. Six, there should be directions on formality, and this should emphasise that a virtual court hearing is still a court hearing and should specifically include provision related to forms of address, appropriate attire, and the importance of attending from a quiet private room. Seventh, there should be provision for regular short breaks during the hearing. My second suggestion for overcoming the challenges that are posed by virtual hearings is that, if possible, the barrister, the solicitor, and the family should all be together. I know that even with a large family, this can be achieved using the conference rooms at Doughty Street, whilst still maintaining the requisite distance between the participants. This arrangement will allow effective explanations to the family of what is going on and will allow the effective taking of instructions. If this isn't possible, and sometimes it won't be possible, then I suggest that there should be a virtual conference before the hearing with the barrister, the solicitor, and the family to explain what will happen and to take instructions on the issues that are anticipated to arise. I'd also suggest that arrangements are made for continuous communication between the barrister and the solicitor and the family during the course of the hearing, perhaps best by chat or instant messaging software, as is used for intra-team communication during arbitration hearings and sometimes in commercial courts. My final practical suggestion is one learned from experience. Last month, I presented a webinar on contributory negligence in employees' liability litigation. Again, you can request that from the clerking team. I planned to join the webinar using my laptop, but when I turned on my laptop, it promptly turned itself off again. And when I did manage to turn it back on, I was greeted by this screen. And I was filled with dread. I grabbed my iPad and joined the webinar using that. But I was told afterwards that for much of the time when I was speaking, the camera was on someone else, and that when I was on the screen, the way that I positioned the camera meant that you could only see half of my face. Hopefully, today's webinar has gone flawlessly. There would be some serious irony if it hadn't. The lesson learned is this: not only should you have a backup for if the technology fails you, but that backup really needs to be properly tested in advance. I hope that this has been a useful overview of the issues connected to virtual hearings in the Coroner's Court. If there are any specific questions arising, then please feel free to send them via the Q&A tool at the bottom of the screen, or to send them to me directly by email, and I've put my email address on the final slide. For now, though, that concludes my part of this webinar, and I'll pass back to Sam to field any questions that we have had.
Thank you very much, Chris and Turan. Do send through any questions. I think just to pick up some of the issues that Chris raised in his talk, I think it's quite interesting to reflect on why it is that I think a lot of us as practitioners for bereaved families feel instinctively uneasy about the prospect of virtual hearings. And it seems to me that the reality of it is, often virtual hearings will be inevitable, and a lot can be achieved with virtual hearings, particularly where there are issues of analysis of policies and what have you. And in those contexts, it may not be that there's much difference between a virtual hearing and an in-person hearing. But I think it's easy to underestimate the impact of the bereaved family just being present in the courtroom. It seems to me that that brings the reality of what everyone is dealing with in an inquest home, to witnesses, to judges, to juries. And also, if you reflect on what it might be like being a witness who might be being economical with the truth, being economical with the truth when you're stood in the middle of a courtroom in front of a jury or in front of a coroner and in front of advocates and in front of the bereaved family and in front of your employers is one thing. Being economical with the truth when you're in pajama bottoms in your living room speaking over Skype is actually probably much easier. And so I think if there are issues of honesty, then I would feel instinctively much more concerned about virtual hearings. So we have had a question about the proposal for jury inquests, if there is one. Chris and Turan, correct me if I'm wrong. My understanding is that at the moment there isn't a proposal for jury inquests, and it's very much a wait and see. And I suppose the scenarios are, by the end of summer, early autumn, Boris starts relaxing some of the restrictions so that jury inquests can go ahead. But if that doesn't happen, and there are obviously real issues about putting 8 or more members of the public in very close proximity for 8 hours a day for several days in a row, then that problem's going to have to be confronted.
Yeah, Sam, I agree that there are no proposals at the moment. We have heard sort of vague rumours on the grapevine. Things like local authority sports halls being used for trials, because they'll allow for people to be spread out. But I don't think that there's anything formal as of yet.
So the next question we have is seeking clarification in relation to the attendance of the press. Is it right that they can only attend remote hearings in person at the court or in an adjacent room or on the phone, but they cannot join on the video call?
That's exactly right.
And it's a slightly odd one, isn't it? Because it's based on the lawfulness of streaming. So there's provision for attendance of witnesses remotely. Hence, you can have a witness over video link. In my view, I think there's a real question about whether the logic of that follows through, because interested persons, it must be foreseen that interested persons can see what's happening in the hearing, but they're not attending as witnesses. They're just receiving a stream. And where's the line drawn? So if it's permissible for a coroner to stream to, mother of the bereaved person, can the coroner also stream to the siblings, to uncles and aunties, to concerned families, to carers, etc., etc. So it's a real issue, and as Chris raised, perhaps the way forward is for perhaps an amendment to the Coronavirus Act or something like that, which permits it. Next question, do we think that the issue of inquests and when they haven't been held and possibly ought to have been might be the subject of a future public inquiry? Yeah, that's I think that's a question directed not so much at the sort of PPE issue, but whether perhaps failings in the inquiry system itself might itself need to be the subject of an inquiry, sort of inquiries, investigating inquiries. Turan and Chris, I don't know if you have thoughts. Certainly my feeling at the moment is that we're really yet to see how this is going to play out in coroners' courts. I think coroners are only just starting to get to grips with it. And I suspect, I may be pleasantly surprised, but I suspect that it will become apparent in due course that some coroners' courts have been doing quite well in facing up to the problem, and some have been burying it, to excuse the phrase. And so perhaps it may well lead to controversies in due course.
I agree, Sam. I think just for the person who asked this, I think it's quite a difficult one, because as I mentioned, the discretion that's been afforded to coroners in making these decisions has been quite wide in the guidance. So if there were to be any inquiry, I'd expect that it would need to be, the inquiry itself would need to be into the guidance given to the coroners to begin with, before we can begin to examine how that guidance has subsequently been implemented. Because by making those kinds of decisions, the coroners are simply following the wide range of discretion that's been afforded to them. So I think it's going to be a difficult one. I agree with Sam that we won't know until we've seen these inquests play out. I think only a few have actually taken place, and very few have been, if any, have been reported. So we don't currently have enough information to track that progress at the moment. So watch this space again on that one, I think.
Yeah, agreed. Oh, sorry, bear with me. We have a further question. If an interested person such as a police force argues that the only fair way for the inquest to proceed is either all interested persons remote in the coroner. Okay, so I think the question is whether either all interested persons should attend remotely or in person, or whether it's fair to have a situation in which some can attend in person and some remotely. Chris,
I think it would be, well, it would seem to me unfair if some of the interested persons were attending in person and some were attending remotely. I would certainly feel, if I was attending in person and others were attending remotely, I would certainly feel that I had an advantage. I don't think it can be perceived to be just if people are attending in different ways.
I think that's probably right. I suppose the only caveat is that whenever we're concerned with the manner in which an inquest is going to proceed, it's to the discretion of the coroner, and I can foresee circumstances in which a bereaved family may have particular concerns around being able to engage with the inquest and want to be in person in court, even if it means them being in person means that state participants are attending remotely. And I can see coroners being persuaded that actually that might be reasonable. I can see state parties not being content with that, but frankly, if it means that bereaved families can be effectively participate in the inquest, and after all, bereaved families are meant to be the centre of the process, then I can also see that it can be justified. I think those are the questions. Interesting questions, so thank you very much. And thank you in particular to Chris and Turan. Pleasure to be joining them in this webinar because they're both fantastic inquest practitioners. And thank you to all for joining us. Again, we will send out a video recording and the presentation. You can ask for a copy of the last webinar if you'd like. Thank you so much. Anything else, Turan and Chris?
No,
nothing from me. Thanks very much, everyone, for joining us today.
Thank you, everyone. Bye-bye.